Good day to you and welcome to another Paddocks Club video tutorial. Today I want to deal with some unusual aspects of exclusive use rights. But to go over the basics first, exclusive use rights under Section 27 and Section 27A are essentially agreements amongst the owners of the common property in a sectional title scheme that only one or some owners will use a part of the common property that they all own. So in essence, the other owners are giving up their rights to possess, use and enjoy a part of their joint property in favour of the one or the identified number of owners who hold those rights. If the rights are registered, they are under Section 27. The holder gets a title deed. If the rights are of a personal nature, they are confirmed under a rule made in terms of Section 27A. In neither case can such a right be held by a person who is not the owner of a unit, and as such a member of the body corporate. Section 27 refers to owners, and Section 27A refers to members of the body corporate, as the only classes of persons on whom those rights can be conferred. So what happens when a person who holds those rights ceases to be the owner of any units and as such a member of the body corporate? In some older schemes also, the rules state that a Mr. A or a Mrs. B hold exclusive use right. And what happens then when they have moved on? In logic, the rule should never specify a person directly, but should state that the owner of a particular unit from time to time, or whoever that may be, is entitled to the use rights. Then the rules only need to be changed either by special or unanimous resolution if the EU right is to be reallocated to a different unit. If you do come across the situation where rules refer to specific people, take steps to have them amended, and as soon as possible. The situation where the holder of a registered EU right ceases to own any units is dealt with in Section 27(4)(b) of the Act, which provides for the automatic vesting of that right in the body corporate. Of course, this is not always the desired result, as normally this happens by mistake, and the body corporate then has to transfer the unit to the purchaser who didn't get all the sectional rights he contracted for, and transfer duty will be payable. But it's better than the right remaining in the hands of somebody who's no longer has any interest in the scheme. And of course the body corporate isn't obliged to give up the rights, although from a theoretical perspective, and strictly speaking, it shouldn't be able to hold them because it's not usually the owner of a unit in the scheme and is certainly not capable of being a member of itself. So it doesn't actually qualify under Section 27 or 27A. I've also come across situations in which the body corporate decides that it won't just give away the EU right, but will sell it to another owner. Finally, I mentioned that when one does want someone who isn't the owner of a unit in a scheme to hold exclusive use rights, the proper legal way to do that is by way of passing a servitude and having that registered. Servitude rights can be held by people who are not owners in the scheme, and one can draft a servitude so that it operates very much like an exclusive use right with similar levy obligations, and that it imposes obligations to abide the scheme's rules. Thank you for joining me in this Paddocks Club video tutorial. If you have any comments or queries, let's deal with them in the discussion forum.